Hi, I'm Anisha, your AI study partner with License to Learn. Before we get started, I want to thank our sponsor, License Closet, for supporting this video. License Closet offers an affordable way to hang your real estate license for just $149.99 per year, with no MLS required. This is a great option for agents who want to stay active, keep learning, and build at their own pace. You'll find the link below. This video is for educational purposes only. Florida real estate laws, rules, and procedures can change, so always verify current requirements through official Florida sources before relying on this information. This content is Florida specific and is a study guide, not a substitute for completing a state-approved course. Now, let's get into today's lesson. Unit 9, Title, Deeds, and Ownership Restrictions. If Unit 8 taught you what land is, Unit 9 teaches how we prove we own it and what rules can limit that ownership. Think, title, idas, the legal story of ownership, deed, the handoff document, and restrictions, the rule book that comes with the property. Here's the exam mindset. Florida questions love to test. 1. How title transfers. 2. What makes a deed valid. 3. What notice recording does. And 4. Which restriction or lien wins when there's a conflict. Pause and answer. What is title in plain English? Answer. The legal evidence that you own the bundle of rights in the property. What is alienation? Answer. Any transfer of title, voluntary or involuntary. Unit 9, Part 2, How Title Moves, Alienation. 1. Voluntary alienation, you choose to transfer. Deed, you gift or sell the property and sign it over. Will, you decide who gets what after death. If you die with a will, you died testate. If you die without a will, you died intestate. Then the state's inheritance rules decide. 2. Involuntary alienation, the transfer happens by law, descent, intestate succession. Title passes to heirs under Florida law. Foreclosure, lender forces a sale to satisfy a mortgage debt. Condemnation, eminent domain, government takes property for public use with compensation. Escheat, if someone dies with no legal heirs, the property can go to the state. Adverse possession, someone earns title by meeting strict requirements over time. Court action, quiet title lawsuit, can clear clouds and establish ownership. Lis pendens, not a transfer by itself, but a public notice that a lawsuit may affect title. Pause and answer, voluntary or involuntary, foreclosure. Answer, involuntary, voluntary or involuntary, gifting by deed. Answer, voluntary. Unit 9, Part 3, Notice, Recording, and Who Wins. Florida tests this idea hard. Recording is how you protect your interest against later buyers or creditors. 2 kinds of notice. Actual notice. You genuinely know a fact. Someone tells you, you see it. Constructive notice. The law treats you as if you know it because it's properly recorded in the public records. Recording rule, exam version. If a conveyance, mortgage, lease, 1 year or longer, is not recorded, it can lose priority to a later creditor or buyer who pays value and had no notice. Why this matters. First in public records often wins, unless a superior lien or special rule applies. Recording creates a public paper trail that forms the chain of title. Abstract of title versus chain of title. Chain of title, the sequence of recorded ownership transfers. Abstract of title, a summary report of recorded documents affecting title. Pause and answer. If a deed is signed but never recorded, is it valid between the parties? Answer. Usually yes, between grantor and grantee, but it may be vulnerable against later buyers' creditors without notice. Which notice comes from public records? Answer. Constructive notice. Unit 9, Part 4, Protecting Title, Title Search plus Insurance. Title work is basically a background check on the property's ownership history. Title company, closing agent, searches the public records, deeds, mortgages, liens, judgments, easements, restrictions. The goal is marketable title, title that is reasonably free of defects so it can be sold, financed. Title opinion: in Florida, a real estate licensee must not casually declare the title is good. Exam cue: if asked what to do, the safe answer is advise the buyer to consult an attorney or obtain title insurance. Title insurance, owner's policy, protects the buyer owner from covered title defects. Lender's policy protects the lender's mortgage interest. Key exam twist: it protects against past problems, hidden defects, not future damage. Pause and answer. Which policy protects the lender? Answer: lender's policy. Which policy protects the buyer, owner? Answer: owner's policy. Unit 9, Part 5, Deeds, the handoff document. A deed is the written instrument that transfers title from grantor, marked the giver, seller, grantee, are the receiver, buyer. Parts you'll see on exams: premises, names, plus date, plus who is conveying to who. Consideration: for $10 and other valuable consideration. Doesn't have to list the full price. Granting clause: the words that actually transfer: grant, bargain, sell, convey. Habendum clause: what estate is being conveyed, most often fee simple. Covenant of seisin: promise the grantor actually owns what they're conveying. Restrictions, exceptions, reservations, limits and carve-outs, appurtenances, rights that run with the land, like certain easements. Legal description must be included. Street address alone is not enough. Delivery and acceptance: deed must be delivered by grantor and accepted by grantee. Florida validity checkpoint: must be in writing. Signed by the grantor in the presence of two witnesses. Pause and answer. Who signs the deed? Answer: the grantor, the one conveying title. What makes a deed work beyond signatures? Answer: delivery by the grantor and acceptance by the grantee. Unit 9, Part 6, Deed Types. What promises come with it? 1. General warranty deed, most buyer friendly. Grantor makes broad promises covering the entire history of title. Florida exam favorite covenants to recognize. Further assurance: grantor will sign needed documents later to perfect title. Quiet enjoyment: grantee won't be disturbed by someone with a superior claim. Warranty forever: grantor will defend the title against lawful claims. 2. Special warranty deed. Grantor's promises are limited to the time the grantor owned the property. Translation: I'll stand behind what happened on my watch. 3. Bargain and sale deed implies the grantor holds title and has the right to convey, but gives limited or no warranties. 4. Quitclaim deed transfers whatever interest the grantor has, if any, with no warranties. Common uses: clearing a cloud, family transfers, divorce settlements, still needs legal guidance. Special purpose deeds, know the names: personal representative's deed, guardian's deed, committee's deed, tax deed. Pause and answer. Which deed gives the least protection to a buyer? Answer: quitclaim deed. Which deed gives the most protection? Answer: general warranty deed. Unit 9, Part 7, Adverse Possession, the squatter trap question. Adverse possession means gaining legal title by acting like the owner long enough in a very specific way. Core conditions: exam language: possession must be open, notorious, continuous, exclusive, and hostile, without permission. Florida splits it into two paths. A. Adverse possession with color of title, wero, a written instrument like a deed that looks like it conveys title, even if it's defective. Exam core: the claimant must have 7 years of continued possession, and the instrument must be recorded to count as color of title. B. Adverse possession without color of title. Harder path. Exam core idea. You must make a formal return or claim and pay property taxes and assessments as required, plus meet the possession conditions. Pause and answer. Does hostile mean angry? Answer, no. It means without the true owner's permission. Color of title means what? Answer, a written instrument that appears to convey title. Unit 9, Part 8, Ownership Restrictions, Government Rulebook. Even with fee simple ownership, your rights can be limited. Government restrictions, the three big tools. 1. Police power, regulates use for health and safety, welfare. Examples: zoning, building codes, safety codes, environmental rules. 2. Eminent domain, government takes private property for public use with just compensation. The taking process is condemnation. 3. Taxation, government can place a lien for unpaid taxes. Exam favorite, property taxes become a first lien superior to other liens starting January 1 of the tax year. Pause and answer. Zoning is an example of what? Answer, police power. If government takes land for a highway, that's what? Answer, eminent domain. Condemnation is the legal process. Unit 9, Part 9, Private Restrictions, Neighborhood Rules plus Access Rights. 1. Deed restrictions, restrictive covenants. Private rules written into the deed or subdivision documents. Examples: no short-term rentals, no commercial trucks, must maintain exterior. Key exam idea: they run with the land, future owners are bound if properly created, recorded. 2. Easements, a legal right to use someone else's land for a specific purpose. Types you must recognize: appurtenant, benefits a particular parcel, dominant over another, servient, transfers with the land. Engross, benefits a person, company, utility easement, does not attach to a dominant parcel. By prescription, created by long-term, obvious, continuous use without permission. By necessity, landlocked parcel needs access. Implied easement, based on prior use and intent when land was split. Encroachment, watch this word, a physical intrusion onto another's land. Fence, driveway, shed. It's not an easement. Pause and answer. A utility company easement is usually which type? Answer, easement in gross. A fence built 2 feet over the line is what? Answer, encroachment. Unit 9, Part 10, Leases, Ownership by Time, Not by Title. A lease is a contract giving the tenant the right to possess and use the property for a time while the landlord keeps title. Types of leases you must match to the description. Gross lease, tenant pays a flat rent, landlord pays most operating expenses. Net lease, tenant pays rent, plus some expenses. Taxes, insurance, maintenance can shift to tenant. Percentage lease, rent is base rent, plus a percentage of business sales, common in retail. Variable, my index lease, rent changes using an index or formula. Ground lease, tenant leases land, often long-term, and may build improvements. Quiet enjoyment, tenant has the right to use the property without unreasonable interference by the landlord. Assignment versus sublease. Assignment, tenant transfers the entire remaining lease term. Sublease, tenant transfers less than the entire remaining term. Tenant becomes a middle landlord. Pause and answer. If the tenant transfers the rest of the lease term, that's what? Answer, assignment. If the tenant transfers only part of the term, that's what? Answer, sublease. Unit 9, Part 11, Liens. Who has a claim against the property? A lien is a legal claim or charge against property as security for a debt. 2 big categories. Exam language. Voluntary liens. Owner agrees. Mortgage. Involuntary liens. Imposed by law. Tax lien. Judgment lien. Construction lien. Two classification styles. A. General liens attached to all property of the debtor. Example, judgment lion, IRS, income tax lion. B. Specific liens attached to one specific property. Example, mortgage, property tax line, construction line, vendor's line. Priority, who gets paid first. Property tax lines are superior to other lanes. Mortgage priority is generally based on recording order. Construction lines can relate back to the notice of commencement timing affecting priority. Judgment line on real property happens when a certified copy is recorded in the county's official records. Satisfaction. Paying off a lien and recording the release clears the cloud. Pause and answer, is a mortgage voluntary or involuntary? Answer, voluntary. Does a property tax line usually outrank a mortgage? Answer, yes, property tax lines are superior. Unit 9, Part 12, Rapid Exam Drill, Answer Out Loud. 1. Title is best described as what? Answer, legal evidence of ownership, the bundle of rights. 2. A deed transfers title by what type of alienation? Answer, voluntary alienation. 3. What kind of notice comes from properly recorded documents? Answer, constructive notice. 4. Chain of title is what? Answer, the sequence of recorded ownership transfers. 5. An abstract of title is what? Answer, a summary of recorded documents affecting title. 6. Name the two title insurance policies. Answer, owner's policy and lender's policy. 7. Who is the grantor? Answer, the person conveying title. 8. A valid Florida deed must be signed by whom and how many witnesses? Answer, signed by the grantor with 2 witnesses. 9. Which deed gives no warranties? Answer, quitclaim deed. 10. Police power controls what? Answer, the use of land, zoning, building, and safety rules. Unit 9, Part 13, Quick Recap, plus what to remember on test day. Test day, Big 6 for Unit 9. 1. Title versus deed. Title is ownership. Deed is the transfer instrument. 2. Voluntary versus involuntary alienation. Deed, will versus foreclosure, condemnation, adverse possession, escheat. 3. Notice. Actual versus constructive. Recording protects priority. 4. Deed validity in writing. Grantor, grantee, legal description, delivery, acceptance, grantor signature, plus 2 witnesses. 5. Deed types. General warranty, most promises, versus quitclaim, no promises. 6. Restrictions and claims. Police power, eminent domain, taxation, plus deed restrictions, easements, leases, and liens with priority basics. One last professional reminder, also exam relevant. Don't promise title is good unless it's correctly based on a current attorney's title opinion. Otherwise, advise title insurance or legal counsel. If this helped, comment Unit 9 and tell me which part you want drilled next: deeds, easements, leases, or liens. Welcome to Key Terms, where we turn real estate words into real estate understanding. Let's begin. Key term title, meaning legal evidence of ownership, the right to the bundle of rights. Florida style example. You can hold the deed, but if there's an unreleased mortgage, your title may be clouded. Key term cloud on title, meaning any claim, lien, or defect that makes ownership questionable. Wrong answer magnet. Thinking a cloud means you don't own it. It means title is questionable until cleared. Memory hook. Cloud and something blocking clear ownership. Key term marketable title, meaning title reasonably free of defects so a prudent buyer lender would accept it. Memory hook. Marketable as sellable and financeable. Question. Title is the ownership, but what is the document that transfers title? Answer, a deed. Alienation, how ownership changes. Key term, alienation. Meaning, transfer of title, any change in ownership. Key term, voluntary alienation. Meaning, owner chooses to transfer, deed, gift, will. Key term, devise. Meaning, transfer of real property by will. Testate, Shaq died with a will. Intestate, died without a will. Key term, involuntary alienation. Meaning, transfer happens by law, not by choice. Descent, passing property to heirs when someone dies intestate. Examples: foreclosure, condemnation, eminent domain, escheat, adverse possession. Question: foreclosure is voluntary or involuntary alienation? Answer: involuntary. Deeds, the handoff, key term, deed. Meaning, written instrument that transfers title from grantor to grantee. Key term, grantor, grantee. Meaning, grantor gives title, grantee receives title. Memory hook, grantor grants. Key term, delivery and acceptance. Meaning, deed must be delivered by the grantor and accepted by the grantee to be effective. Wrong answer magnet. Thinking recording is what makes it valid. Recording protects priority. Delivery acceptance makes it effective between parties. Florida exam detail. A deed must be signed by the grantor in the presence of two witnesses. Question: who signs the deed? Answer: the grantor. What a deed must have, exam target. Key term, legal description, meaning a precise description that identifies the property, lot, block, meets, and bounds, or government survey. Wrong answer magnet, using only a street address. Address helps locate, legal description identifies. Key term, habendum clause, meaning to have and to hold. States the estate being conveyed, often fee simple. Key term, consideration, meaning something of value given for the transfer, money, love, and affection, etc. Key term, appurtenances, meaning rights that run with the land, like certain easements, and transfer with the property. Question: if a deed is missing a proper legal description, what's the exam safe conclusion? Answer: the deed may be defective because the property isn't clearly identified. Deed types, promise levels, key term, general warranty deed, meaning broadest protection, grantor warrants title against defects from any time in history. Memory hook, general bond covers everything. Key term, special warranty deed, meaning limited protection, grantor warrants only against defects arising during the grantor's ownership. Memory hook, special, only my time. Key term, bargain and sale deed, meaning implies the grantor holds title and can convey it, but gives limited or no warranties, depends on wording. Key term, quitclaim deed, meaning transfers whatever interest the grantor has, if any, with no warranties. Common use, clearing a cloud or transferring between family divorce situations, still use legal guidance. Question: which deed gives the least buyer protection? Answer: quitclaim deed. Notice: plus recording, who wins. Key term, recording, meaning placing a document into county public records to protect priority and give notice. Key term, actual notice, meaning you truly know a fact, you were told, you saw it, you read it. Key term, constructive notice, meaning the law treats you as if you know because it's properly recorded. Key term, chain of title, meaning the sequence of recorded transfers, claims affecting ownership over time. Key term, abstract of title, meaning a summary of recorded instruments affecting title. Question: recording creates what kind of notice? Answer: constructive notice. title search plus title insurance key term title search, meaning review of public records to identify liens, easements, restrictions, and defects in the chain of title. Key term title insurance, meaning insurance against covered title defects that already exist, past problems, discovered or undiscovered. Wrong answer magnet, thinking it covers future events like a broken roof. It covers title defects, not property condition. Key term, owner's policy, lender's policy. Meaning, owners protects buyer, lenders protects the lender's mortgage interest. Question, if the lender requires title insurance, whose interest is protected by that required policy? Answer, the lender's. Liens, claims against property. Key term, lien. Meaning, a legal claim against property to secure payment of a debt. Key term, voluntary lien. Meaning, owner agrees, mortgage. Key term, involuntary lien. Meaning, imposed by law, property tax lien, judgment lien, construction lien. Key term, general lien versus specific lien. Meaning, general attaches to all of debtor's property, specific attaches to one parcel. Key term, priority. Meaning, the order lines get paid often first in time record with special exceptions. Exam anchor, property tax lines are superior. Question, mortgage is voluntary or involuntary? Answer, voluntary. Easements plus restrictions. Key term, easement. Meaning, a legal right to use someone else's land for a specific purpose. Key term, appurtenant easement. Meaning, benefits a parcel, dominant, and burdens another, servient. Transfers with the dominant land. Key term, easement in gross. Meaning, benefits a person/company, like utilities, not tied to a dominant parcel. Key term, restrictive covenant, deed restriction. Meaning, private rule limiting use of the property, usually runs with the land when properly created, recorded. Key term, encroachment. Meaning, physical intrusion onto another's land, fence, driveway, shed. Not an easement. Question, utility easements are usually what type? Answer, easement in gross. Adverse possession plus lawsuit flags. Key term, adverse possession. Meaning, gaining title by meeting strict possession requirements over time. Open, notorious, continuous, exclusive, and hostile, without permission. Wrong answer magnet. Hostile means angry. On the exam, it means without permission. Key term, color of title. Meaning, a written instrument that appears to convey title, even if defective. Key term, quiet title action. Meaning, lawsuit to remove clouds and establish ownership. Key term, lis pendens. Meaning, recorded notice that a lawsuit is pending that may affect title. Question, hostile possession means what? Answer, possession without the true owner's permission. Florida laws and rules can change. Verify the most current requirements through the Florida statutes, Florida Administrative Code, DBPR, and the Florida Real Estate Commission. Before you go, make sure you like, subscribe, and share this video with anyone who's preparing for the Florida real estate exam. If this lesson helped you, that tells me I'm doing my job. And if you're ready for more structured support, live instruction, and accountability, you're invited to join our online classes through License to Learn. You'll find the sign up link below. Keep showing up, keep studying, and keep building the future you're working toward. I'll see you in the next lesson. Florida laws and rules can change. Verify the most current requirements through the Florida statutes, Florida Administrative Code, DBPR, and the Florida Real Estate Commission.